Why is social media so important today?
Although major social media platforms have been around for nearly 2 decades, the medium has become especially robust in the last 5 years. Today, some sources estimate a social networking penetration rate of over 90%. The average U.S. teen spends nearly 5 hours a day on social media, according to the Gallup Familial and Adolescent Health Survey, and U.S. adults spend upwards of 2.5 hours per day on social media, according to a study by Simon Kemp. These rates continue to trend upwards. Social media platforms provide unique services that would have been unimaginable 30 years ago. They provide a space where people with common interests from opposite sides of the world can connect. They allow individuals to produce and consume content for free, and in some cases even monetize it. Beyond decentralized entertainment distribution, social media platforms have become increasingly significant in the spheres of politics and news media. As of September of this year, Pew Research Center found that a strong majority of adults in the United States, 58%, consume their news through their digital devices, and of that, 70% stated that they consumed their news through social media. Social media platforms have also become outlets for politicians to reach constituents directly and cheaply, leveling the playing field and democratizing elections. Even platforms such as TikTok, that are usually associated with short-form entertainment, are increasingly used as political outlets. How does the Florida law restrict social media platforms' ability to engage in content moderation by removing, editing, or arranging user-generated content?
Florida Senate Bill 7072, signed into law in May 2021, focuses on regulating large technology companies, particularly social media platforms. The law primarily addresses transparency and accountability concerns rather than directly restricting content moderation. One key provision prevents social media platforms from deplatforming political candidates during specified periods leading up to elections. This means that these platforms cannot suspend the accounts of political candidates during crucial campaign periods, with penalties imposed for non-compliance. Another significant aspect of the law requires social media platforms to provide clear and detailed justifications for content removal decisions. This provision aims to enhance transparency in the moderation process, ensuring that users receive explicit explanations for any removal, editing, or arrangement of user-generated content. Additionally, the law permits users to sue platforms if they believe they have been unfairly treated, giving individuals a legal recourse against perceived moderation injustice. While Florida Senate Bill 7072 does not directly restrict the ability of social media platforms to engage in content moderation, it introduces measures aimed at preventing certain actions, particularly against political candidates. How does the Florida law require social media platforms to provide individualized explanations for certain forms of content moderation?
Florida Senate Bill 7072 mandates social media platforms to provide individualized explanations for certain forms of content moderation, emphasizing transparency in their decision-making process. The law requires platforms to furnish clear and detailed justifications when they remove, edit, or arrange user-generated content. Specifically, social media companies must articulate the reasons behind their moderation actions in a manner that is specific to each case. This provision, from the view of the state, is designed to afford users greater insight into why their content has been subjected to moderation, ensuring transparency and accountability in the platform's content management process. By requiring individualized explanations, the law claims to prevent arbitrary or opaque content moderation decisions, enabling users to understand the basis for the platform's actions. This provision is particularly relevant in cases where users believe their content was unfairly treated or wrongfully moderated. Users have the right to receive explicit and personalized justifications, empowering them to challenge moderation decisions if they feel their content was handled improperly. Florida Senate Bill 7072 claims to foster a more transparent relationship between social media platforms and their users by compelling platforms to provide tailored explanations for content moderation actions. However, its attempt to do so undermines the First Amendment rights of social media companies and ultimately harms the state's speech climate. Why did Florida enact its social media law?
The motivations behind the passage of Florida Senate Bill 7072 are subject to interpretation, and opinions vary among experts. Proponents, including Governor Ron DeSantis, assert that the law was enacted to address concerns related to perceived censorship and biased content moderation on social media platforms. They argue that the legislation aims to ensure transparency, protect free speech rights, and prevent deplatforming of political candidates, particularly during election periods. However, critics and legal experts have offered alternate perspectives. Some believe that the motivations behind the bill might be rooted in political considerations, especially given the context of increasing debates about the role of social media in shaping public opinion. Critics have suggested that the legislation could be a response to perceived biases against certain political ideologies on major tech platforms. Additionally, some experts argue that the passage of such laws might be part of a broader trend where states are seeking to regulate the behavior of large technology companies, particularly in the absence of federal legislation addressing these issues. The motivations, therefore, may be multifaceted, encompassing concerns about free speech, political considerations, and a desire to assert state authority over tech platforms. It's important to note that individual perspectives on the motivations behind the bill may vary based on one's stance on issues related to content moderation, free speech, and the role of government in regulating online platforms. Which tier of scrutiny should the court review Florida's law with?
In reviewing Florida Senate Bill 7072, the court should use strict scrutiny. For First Amendment cases, including issues related to freedom of speech on social media, strict scrutiny is often applied. The First Amendment provides robust protection for free speech rights, and strict scrutiny ensures that any government restriction on speech is rigorously examined to determine whether it is absolutely necessary to achieve a compelling governmental interest. This high standard reflects the importance of safeguarding core constitutional rights, such as freedom of expression, against governmental interference. When strict scrutiny is applied, the government bears a heavy burden to justify its actions, and the law or regulation in question must be narrowly tailored to achieve a compelling state interest without unnecessarily infringing on constitutional rights. In this specific case, it is evident that strict scrutiny should be applied given the long history of First Amendment protections of editorial judgment that implicate strict scrutiny, such as in the case of Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston. Despite key differences between the forms of speech originally protected in editorial judgment cases and social media platforms practice forms of speech that constitute editorial judgment, such as the use of community standards and warning labels. The First Amendment provides robust protection for free speech rights, and strict scrutiny ensures that the government restriction on speech is rigorously examined to determine whether it is absolutely necessary to achieve a compelling government interest. Because content moderation laws on social media platforms are viewed as a slippery slope, and because the rights they are protecting are so fundamental, strict scrutiny is necessary.
Do social media companies resemble newspapers which can control their editorial content?
Social media platforms, like newspapers, exercise editorial control over content. They curate and moderate content to create a certain user experience, much like a newspaper editorial team decides what stories to publish. In Packingham versus North Carolina, the Supreme Court recognized the internet as a crucial platform for the exchange of ideas, akin to traditional public forums. This implies that online platforms, like newspapers, have the editorial discretion to shape the content presented to their users. On the other hand, social media platforms differ from traditional newspapers in significant ways. Unlike newspapers, social media platforms often serve as an interactive space where users generate a substantial portion of the content. Section 230 of the Communications Decency Act provides legal immunity to platforms for the content posted by users, distinguishing them from the editorial responsibility that newspapers bear for their content. Courts have recognized this distinction in cases like Zoran versus America Online, highlighting that internet platforms are not publishers in the traditional sense. While social media platforms engage in content moderation, their role in facilitating user-generated content makes them distinct from traditional newspapers. The legal framework and court decisions reflect the unique nature of online platforms and the challenges in drawing direct comparisons to traditional media outlets. Though the balance between government interest and the rights of institutions may be different in the case of social media platforms still retain similar rights to content moderation. Does the compelled speech doctrine protect the rights of social media companies?
Yes. The compelled speech doctrine is a legal principle derived from the First Amendment, protecting individuals and entities from being forced to express views with which they disagree. It asserts that the government cannot compel individuals or, crucially, organizations to convey a specific message, as doing so would infringe upon their freedom of speech. Notable examples of the compelled speech doctrine include West Virginia State Board of Education versus Barnett in 1943, where the Supreme Court held that students could not be forced to recite the Pledge of Allegiance, and Woolley versus Maryland in 1977, which ruled that individuals cannot be compelled to display a state motto on their license plates. In the context of social media companies, the compelled speech doctrine is relevant when considering laws or regulations that attempt to force platforms to host or promote specific content against their will. This debate often centers around whether these companies, as private entities, should be treated similarly to traditional publishers or whether their content moderation practices are protected under the First Amendment. Forcing platforms to host specific content would violate their right to editorial discretion, protected by the compelled speech doctrine. Historical precedent and interpretation strongly indicate that the compelled speech doctrine does protect the rights of social media companies.
Do social media companies engage in commercial speech?
Commercial speech refers to communications or expressions made by businesses or individuals that have the primary purpose of proposing a commercial transaction. It involves speech related to the economic interests of the speaker and the audience. The legal treatment of commercial speech is not as stringent as that of other types of expression, but it is not entirely unprotected either. One relevant case that shaped the understanding of commercial speech is Central Hudson Gas and Electric Corporation versus Public Service Commission. The Central Hudson test established a framework for assessing the constitutionality of government regulations on commercial speech. It involves a four-part analysis, where commercial speech is protected if it concerns lawful activity and is not misleading, and if the government's interest in regulating the speech is substantial, and the regulation directly advances that interest. In the context of social media platforms, the question of whether they engage in commercial speech is complex. While these platforms serve as spaces for various forms of expression, a significant aspect of their operations is commercial. Advertising and sponsored content prevalent on social media are forms of commercial speech. Platforms like Facebook, Twitter, and Instagram generate substantial revenue from targeted advertisements, and the content of these ads often falls within the category of commercial speech. However, social media platforms also host non-commercial speech that does not involve commercial transactions. The distinction between commercial and non-commercial speech becomes crucial when considering the extent to which government regulations may apply to these platforms. Commercial speech on social media platforms, particularly in the form of advertisements, may be subject to certain regulations, but the broader landscape of user-generated content is entitled to a higher level of protection under the First Amendment. Will Florida's law increase or decrease free speech on social media?
Florida Senate Bill 7072, while aiming to protect certain aspects of free speech, introduces a regulatory framework and stifles the ability of social media platforms to moderate content effectively, leading to unintended consequences and diminishing the overall landscape of free expression on these platforms. Senate Bill 7072 inserts the government into the content moderation practices of private social media platforms by imposing restrictions on the deplatforming of political candidates during election periods and requiring detailed justifications for content moderation decisions. The law is an attempt to influence and regulate the editorial policies of these platforms. The legislation may have a chilling effect on social media platforms' ability to enforce content moderation policies effectively. Fearing legal repercussions, platforms might become more cautious in taking down potentially harmful or misleading content, which could lead to an environment where disinformation and harmful speech proliferate. The law's focus on political candidates during election periods may result in selective enforcement and heightened scrutiny of political content. This could lead to a situation where platforms, fearing legal consequences, overly scrutinize political speech, inadvertently restricting the free expression of certain viewpoints.
Does the Florida law create a slippery slope towards censorship?
Yes, there are plenty of examples in American history where government regulations, once implemented, led to concerns about a slippery slope, meaning that subsequent regulations or actions followed, potentially eroding liberties or establishing troubling precedents. The second Red Scare in the 1950s, fueled by anti-communist sentiment, led to government investigations and the blacklisting of individuals suspected of having communist ties. The House Un-American Activities Committee and Senator Joseph McCarthy's hearings raised concerns about the government infringing on individuals' rights to free association and political beliefs. The fear was that these actions could set a precedent for government overreach in the name of national security. Content moderation on social media is a complex process. While the intention behind laws like Florida's Senate Bill 7072 may be to safeguard free speech, such regulations can create a slippery slope. When governments intervene in content moderation policies, there is a risk of chilling platform owners' ability to regulate harmful or false information effectively. These laws set a dangerous precedent by introducing government oversight into the editorial decisions of private companies.